Welcome all, my dear friends. Let us enter into another significant arena of the world of patents, that is known as patent drafting. So, after having a lots of discussions on the most significant sections, rules, and forms of the Patents Act 1970 and the Patents Rules 2003, respectively, let us enter into this beautiful and most important arena of the world of patents. Okay, so let us continue with patent drafting. Fine. So patent drafting or otherwise we can say patent specification writing. Okay, and today I have taken the topic patent specification. Okay, so let us proceed with this. Now, a beautiful thought, friends. Just listen it carefully. Grasp the essence from the seed and let it drip from your fingertips. I'm again reading it, friends. Grasp the essence from the seed and let it drip from your fingertips. And that's called drafting. I hope it is clear. Fine. That means I have tried to explain you this term drafting in a literal way with showing some beautiful clips. Fine. I hope you get it. Okay. So let us proceed. Now we will have a comparison because whenever we say what is a draft, normally we go to its literal meaning. Fine. So first of all, we will go to the literal meaning of a draft. Fine. Okay. We can say that a draft is a preliminary version of a piece of writing. Fine. Or it is or we can say a draft is a written order to pay a specified sum. Fine. So this is the normal and literal meaning of draft. Now we will go towards what is a patent draft. Fine. Because this is the demand of our legal world or the world of patents. Fine. Okay. Let us see. A patent draft is a technical document presented in a legal format that has two primary functions. Fine. Number one is to establish novelty, and point number two is to establish inventive step or non-obviousness of an invention. Fine. Also, we can note it that patent drafting is the process of writing the patent description and claims. Fine. When the patent is issued, the draft is the specification part of the document. So, whenever you will try to understand the meaning of this statement that I have written in the note part, then your confusions will be clarified. Fine. So, just remember, patent drafting is the process of writing the patent description and claims. Fine. And when the patent is issued, the draft is the specification part of the document. Fine. So the comparison has been done. Let us proceed. Today we will discuss about FER, that is First Examination Report. Okay. So let us proceed. Once the patent application is examined, the patent office issues an examination report to the patent applicant, which is generally known as First Examination Report or FER. Okay. When the patent application got examined, fine, at that time, that means after the completion of the examination of the application, the patent office issues a report. It issues a report or an examination report to the applicant. Okay, and this report or that report is known as first examination report. Fine. The examiner submits the FER to the controller. Okay. So this examination is done by the examiner, and then the examiner just submits the FER to the controller. Fine. Next, it usually contains, that means FER usually contains prior arts similar to the claimed invention. Fine. The next point is prior art here means existing documents before the date of filing similar to the claimed invention. Okay. And FER need not be commercially available. Okay, it is not commercially available. It is just evidence. We can say that it is just an evidence that proves that, or we can say it is just an evidence which proves that the claimed invention is already known. Okay, that means this is a proof of acknowledging that this invention is already known. I hope it is pretty clear now. That means what is FER and its whereabouts. Okay, let us proceed for a deeper knowledge. Okay, now examiner and controller or the patent office, their duties are over. Now, what is the responsibility of the applicant? Fine. What is the responsibility of the patent applicant? Okay. The applicant should reply to the objections, if any, and place the application in order for a grant within 6 months from the date of issue of the FER first examination report. Okay. That means the time period given to an applicant, a patent applicant, is 6 months. That means within this time, the applicant should reply to the objections if there are any and place the application in order for a grant. Fine. The next point. In this case too, if the reply to the examination report is not made within the prescribed time limit, that is 6 months, the application is deemed to be abandoned. Just remember this. If it is not done, or if it is if the applicant is not if the applicant has not given any reply to the objections and within 6 months, then the application is deemed to be abandoned. Fine. The next point is missing the deadline for filing request for examination can prove fatal for the patent application. That means if an applicant misses the deadline for filing a request for examination, that is RFE, okay, then it can be fatal for the application. Because what happens, missing the deadline could eventually kill the patent application. Fine. If the deadline is missed, it is automatically patent application is killed. If the request of examination is made within the prescribed time limit, the Indian Patent Office takes up the application for examination. Okay. And if the request has not been done in the prescribed time, simply the patent application is killed, we can say here. The word is used. Fine. So, you can just compare these two things. Here, if the applicant misses the deadline to apply for, that means if the applicant misses the deadline for requesting for examination, then the application is killed. Okay, the patent application is eventually killed. And here what happens, if the examination report is already reached to the applicant, and now the applicant within 6 months does not reply to the examination report in case of any objections or so and so, then the application is abandoned. Okay, so try to differentiate between these two. Fine. Time factor. Okay, the normal request for patent examination can be filed within a period of 48 months from the priority date, or we can say date of first filing of the invention. Can be provisional patent or complete patent or non-provisional patent as well, or date of filing of the patent application, whichever is earlier. So I am reading it like this. The normal request for patent examination can be filed within a period of 48 months from the priority date or date of filing of the patent application, whichever is earlier. Just remember this thing, whichever is earlier. Okay. The next point is, if the patent examination request is not filed within the specified time limit, the patent application shall be treated as withdrawn by the Indian Patent Office. Now, this is another thing. If the patent examination request is not filed within the specified time limit, the patent application shall be treated as withdrawn by the Indian Patent Office. Now you try to link up this with the cases where we have discussed either the patent application is killed or the patent application is abandoned. Try to find out, that means try to map to which situation this is similar, we can say. This situation is similar to which situation? That is already discussed. Okay. Now, the next point is, it is mandatory under the Indian Patent Act 1970 to file a request for patent examination as per the prescribed timeline. That means, if you want your application to be examined, then it is mandatory or compulsory to request for it. That means RFE should be done. Request for examination should be done. Fine. Next, process of examination. The process of examination starts with filing a request for examination. Unlike publication, this is not an automatic process. That means, just remember, we also know that publication is an automatic process, but examination process is not at all an automatic process. Only after receiving the request for examination or RFE, the controller transfers the patent application to the patent examiner. Next is, the request for examination has to be made within 48 months from the date of priority or filing, whichever is earlier. Okay, the request for examination has to be made within 48 months from the date of priority or filing, whichever is earlier. Just remember this. Now, there are some basics, or we can say basis of examination report. What is the basis of an examination report? The patent examiner examines the patent application and prepares the examination report on the basis of various patentability criteria like patentable subject matter. Okay, what are the basis we are studying? So, number 1 is patentable subject matter. Number 2 is novelty. Number 3 is inventive step. Number 4 is industrial application. And number 5 is specification enablement. So, these are the basis for an examination report. Fine. Next, responsibilities of the patent examiner. We can say the responsibilities of patent examiner for examination of a patent application include, other than the examination, point number 1 is to conduct a comprehensive investigation of an application and prepare a report under section 12. Okay. Then the next point is to conduct an inter-office search covering all 4 patent office. Okay. And the next point is to raise objections rather than comment on missing forms. Okay. Rather than commenting on the missing forms, raising objections are more, we can say, are more encouraged. Okay. So, section 12 is about examination of application, as we already know. Okay. Examiner's report. Okay, in this case, the patent application is found to be in order for grant. The patent is granted if there is no pre-grant opposition filed or pending by a third party. This is the situation. Fine. Now, the examiner's report will be a permanent part of a file's note sheet and non-editable at the controller's end. Okay, that means the controller also can't edit it. Okay. The next point, include a draft summary or gist of objections. This gist editable at controller's end. Okay, just remember this also. This gist is editable at controller's end. Okay. The next point is include any amendments to the complete specification. Okay. And the final point is the applicant is required to comply with all the requirements imposed upon him by the Act as communicated through FER or subsequent communication at the earliest. Okay. So what happens? The applicant should comply with all the requirements imposed upon him by the Act as communicated through FER or subsequent communication at the earliest. Fine. Okay. FER is linked to section 21. Okay. If the applicant fails to respond to the FER within 6 months from the date of issuance of FER or within an extended period of 3 months, the application is deemed to have been abandoned as per section 21 subsection 1. The next point is a communication to that effect is sent to the applicant for information. The period of 6 months is extendable only once for a maximum period of 3 months. If requested, that too also if requested in form 4 within the prescribed period of 6 months along with fees. The next point is if the response or amendment filed by the applicant do not satisfy the requirements laid down by the Act, the controller offers an opportunity of hearing and decides the case on merits. The next point is the hearing may also be held through video conferencing or audio-visual communication devices. Fine, such hearings shall be deemed to have taken place at the appropriate office. And what is an appropriate office? You can refer what? You can refer Rule 4 of the Patents Rules 2003. Similarly, we can go for what is Section 21. The title for Section 21 is Time for Putting Application in Order for Grant. Fine. Now, FER is linked to Section 14. Okay. In all cases of hearing, written submissions and the relevant documents, if any, shall be filed within 15 days from the date of hearing. Okay. When the applicant refiles the documents within stipulated time, the application has to be examined in a fresh manner by the examiner. Fine. Next. Upon examination, if it is found that the requirements of the Act have been met, the patent is granted. And the next point is, if the applicant contains any of the objections communicated to him by the controller or he refiles his specification or other documents along with his observations as to whether or not the specification is to be amended, an opportunity of being heard is given. Fine. So just remember these things and we will proceed. The next point is, after hearing the applicant, the controller may specify or permit such amendments as he thinks fit and grant the patent. The controller may refuse to grant the patent if requirements of the Act and rules are not complied with. Okay. Now, next point is, no patent is refused without giving an opportunity of being heard under Section 14. A decision by the controller under Section 15 for refusal of patent shall be a speaking order. Fine. Such an order of controller under Section 15 is appealable before the IPB or Intellectual Property Appellate Court. Fine. Section 14 is actually consideration of the report of examiner by controller, and section 15 is power of controller to refuse or require amended applications, etc. in certain cases. Fine. So please refer to these two sections and try to get the gist of this particular topic, that is FER as linked to section 14. Fine. So friends, enrich your brain cell with proper food and proper knowledge. So thank you all my dear friends for listening to me and watching my video. Please like, share and subscribe my channel. Please keep questioning. Please keep learning and keep enjoying. Thank you so much. God bless you. Jai Hind.